Thank you all for coming to hear this Chicago Best Ideas talk about William Winslow Crosskey. On my way before this talk, I was in the elevator two separate times, actually, with one of my colleagues here, and they asked what I was talking about, and I explained I was talking about the important work of Professor Crosskey, and each of them separately responded, "Who? Who is that?" And I said he was a constitutional law professor on the University of Chicago faculty. He had a lot of big ideas. Who indeed? So let's talk about who was Crosskey. 90 years ago, William Winslow Crosskey showed up at the University of Chicago Law School and became an incredibly popular and influential constitutional law professor. He came in with quite a reputation. He had been a brilliant student at Yale Law School, a law clerk for the Chief Justice of the United States. He'd worked for a former Solicitor General of the United States who later said that Crosskey's brain was the best piece of legal equipment he had ever encountered. He also had a reputation for being a little bit arrogant and doing things his own way. According to another scholar, at law school, Crosskey refused to keep notebooks and also let it get around that he never read the cases in preparation for class. And yet then he was always ready to outmatch not only his classmates, but his professors on all of the material. So when Crosskey arrived in 1935, according to Philip Baude, it was thought that he might add a note of, quote, professionalism, unquote, to a strongly theoretical faculty. But the faculty was shortly disabused of any such notions when Crosskey's first course, Federal Income and Estate Taxation, resolved into a study of exclusively constitutional law issues. For Crosskey was one of those brilliant men who was obsessed by the conviction that life is far simpler than the nitwits running the world perceive it to be. With such iconoclasm, it was idle to suppose that he would attempt anything less than a revolution in constitutional scholarship. So the main thing Crosskey produced during his several decades in the faculty was this, a 2-volume book, Politics and the Constitution in the History of the United States, that set forth everything Crosskey thought had gone wrong in our understandings of the Constitution, and in even our understandings of how to study the Constitution. And we have an account from one student in his class, so the first day of constitutional law class, to give you a sense of how class started out. On the first day of class, Crosskey would storm into the podium and say, "You have all heard, gentlemen, that James Madison is the father of the Constitution, that Oliver Wendell Holmes Jr. of Massachusetts was our greatest Supreme Court justice, and that Louis Brandeis was the leading authority on the jurisdiction of the federal courts. Before I finish, I propose to demonstrate to you that Madison was a forger. He tampered with the notes he kept of the debates at the Federal Constitutional Convention in order to suit his own political advantage and that of his party. Holmes undoubtedly knew a great deal about Old English law, but he was not the most eminent authority on American constitutional history. And as for Brandeis, his opinion in Erie versus Tompkins demonstrates that he did not understand the true meaning of the judiciary provisions in Article 3 of the Constitution." Now, according to the students, by the end, they were indeed all convinced of these propositions, and these and many more are some of the ideas in Crosskey's work, which I'll talk about in a minute. When this book came out in 1953, it was greeted as a constitutional revolution. The initial reviews were very favorable. Arthur Kroc in the New York Times devoted 2 whole columns to everything that was in the book and why it was so important that all lawyers and judges understand what they'd missed about the Constitution. It got, I'm trying to find them all, but I think it was reviewed in over 50, maybe 75 law journals by constitutional scholars of every stripe. It was a big deal. But after the initial favorable reviews, the tide started to turn. So the legal historians did not like Crosskey. One of the most famous legal historians, Julius Goebel at Columbia, reviewed Crosskey's book. I'll sum it up this way. "Let it be said that Mr. Crosskey's performance, measured by even the least exacting of scholarly standards, is without merit." The Columbia people didn't like him. The Harvard people really didn't like him. One Harvard law professor reviewed the book and said, "It is unfortunate that Mr. Crosskey's years of research should have produced a book so incomplete in the evidence it presents, so curious in its reasoning processes, so bitter in its address to unwelcome ideas and to the men identified with them." And then Henry Hart got his hands on Crosskey. Henry Hart, a Harvard law professor, who published a very important book in 1953 as well, called Hart and Wexler's Federal Courts. Talk about that in another lecture. He started his review of Crosskey this way. The Don Quixote of Chicago breaks far too many lances in his onslaughts upon the windmills of constitutional history to permit a detailed review of each adventure. He focused only on 2 chapters. In the precise pattern of the Knight of La Mancha, the Knight of Hyde Park has constructed a never-never world of his own, the charm of which, if it has charm, lies in its occasional illumination of the paradoxes and foibles of the real world. And things sort of went downhill from there. There's a series of essays by a recent constitutional historian, Ken Kirsch, drawing on some work by Mary Bilder, who I'll talk about in a minute, that just tries to address the question, Crosskey, why did people hate him so much? All right, so let's talk about that. The legal culture rejected Crosskey's ideas when they came out. The many things he argued for in the book were thought to be inadequately supported or often just so out of step with what American constitutional law looked like. This is the 1950s, not today. So out of step with what American constitutional law looked like that he just couldn't be taken as a serious constitutional scholar. That's part of what Professor Hart's alluding to when he suggests that Crosskey was the Don Quixote of Chicago, the Knight of Hyde Park. Right? He's just off in his own never-never world trying to promote constitutional ideas that have nothing to do with what constitutional law and lawyers really care about. Crosskey died in 1962, 63 years ago. By then, obscure, unhappy, generally people thought, wow, that was a lot of brilliance wasted on not much. But in the 62 years since then, a funny thing has happened. A lot of the ideas that Crosskey put forth and argued for in his book have started to come back in vogue a little bit. We might say the hour of Crosskey is finally coming around a little bit late. So in our time this talk, I'm just going to give you 8 examples. Number 1, probably the thing for which Crosskey was the most mocked at the time in some ways, was his method of interpreting the Constitution, originalism. So as Crosskey argues in the start of the book, the aim of these initial volumes is to present, for the first time, the historic and intended meaning of the underlying constitutive document, the Constitution of the United States. According to Crosskey, everybody had lost sight of the true meaning of the Constitution because of the radically changed usage of the present day of certain words that constitute the key to the meaning of important provisions of the Constitution, as well as to even understanding the 18th century literature about it. He said, we try to read the Constitution as if the words meant something today without trying to understand what the words originally meant to the people who used them. And he said, a somewhat comparable change in various basic legal and political ideas, which is not generally recognized to have occurred. We were reading the Constitution in a modern context, not in the original context when it was enacted, and so we didn't understand what it was doing. Between the two of them, they effectively conceal that the Constitution today is not understood. Now, Crosskey went on to say, now, sure, part of this is politics, right? Part of this is the way constitutional law works. Politics, it is needless to say, has entered deeply into all these matters, but fortuitously changed word meanings and forgotten legal and political ideas have made the works of politics easier, and in these latter days have effectively prevented that work in various of its earlier phases from being perceived. In other words, here we were in the 1930s, 40s, 50s, the Supreme Court deciding a lot of things about the Constitution that no longer had much connection to what the Constitution actually said at the time it was enacted and made law. But people didn't even appreciate how radical the changes had been because nobody had tried to set out what did the Constitution actually require, and do the hard work of figuring out what was the original meaning, what was the original legal context of the Constitution, and what kind of government did it create. Crosskey said, wow, somebody probably ought to do that, and he decided it should be him. At the time, as you get a flavor from the reviews, people thought this was a wild project. But as you may know now, originalism is not such a wild project anymore. Indeed, by my count, 7 of our 9 Supreme Court justices say that they are originalists of one stripe or another, including all 5 of the most recently nominated and confirmed Supreme Court justices. That's 3 Republican nominees, 2 Democratic nominees, who each said at their confirmation hearing that they are originalists. So this idea from Crosskey, anyway, no longer seems so radical, so out of the mainstream. Seems like a good idea for somebody to try to figure out what the Constitution actually means. That most of the book, though, is devoted to substance. Right? That's his setup. So what does Crosskey think is a matter of substance? His biggest view, the half of the volume is devoted to, is to the proposition that Congress has a lot of power. This, too, once seemed quite controversial, right? So Crosskey got his start as a lawyer in the 1930s when people were arguing at whether the Securities and Exchange Act was constitutional. In fact, his sort of idea for the book originally came because he wrote a memo as a lawyer about the Securities and Exchange Act. Then he got the job here and thought, well, I'm going to need to write a big article to get tenure, so I guess I'll write a big piece about the Constitution of the Securities and Exchange Act. That seems like something I could get done. But the more he dug into it, the more he realized there were a lot of complicated constitutional issues there that nobody had really written about. And it, 17 years later, turned into a 1,000-page book. So once again, at the time, Crosskey's view that things like the securities laws and federal regulation of the economy were constitutional seemed like a lot. Now, of course, this is where the doctrine is. Now, Crosskey went further than our current Supreme Court doctrine. Crosskey did not just think lots of things are commerce. Crosskey actually had a more radical and interesting theory of the Commerce Clause, which is that when it says Congress has the power to regulate commerce among the several states, the words among and states don't mean what you think they mean now. States, he argued, with lots of evidence, was used not just to refer to the places or the governments of Illinois or New York, but was often referred to the people of Illinois and New York. So you would say the state of New York, the state of Illinois has a lot of grain. The state of Illinois generally votes for Democrats. And you'd just be referring to the population of the state of Illinois by saying that. The same thing for every other state. And that the word among didn't necessarily mean things that went from one state to another. It just meant anything that was in there in any of the people. So when Congress had the power to regulate commerce among the several states, that meant Congress had the power to regulate commerce, which he had a broad view of, that took place anywhere involving a person in any of the states. Anything that happened between two people in this classroom would be commerce among among Illinois, and therefore be regulated by Congress. In other words, the Commerce Clause itself, read in 18th century language, he argued, meant Congress can regulate anything that happens domestically. They can just regulate anything that happens. Now that, is a little more eyebrow raising. But here too, others are starting to agree. Professor Richard Primus at Michigan is publishing a new book arguing that Congress is not limited to its enumerated powers and has plenary power. Professor John McHale at Georgetown, a group of quite sophisticated constitutional historians, have all gone back and more carefully reread the records of the Constitutional Convention, the influence of James Wilson, and they've all concluded this is actually right. Congress was supposed to have plenary power, not a limited set of powers, as Thomas Jefferson and others later argued. So here too, Crosskey's hour is starting to come around again. Now, one obvious objection to this argument brings us to Crosskey's third idea, which is, okay, if commerce among the several states actually secretly means, in founding era speak, anything in the United States, why bother with all the other enumerated powers? Why do they also say Congress can coin money and raise an army and punish piracy and provide for copyright laws and so on? Like, those seem obviously redundant if the Commerce Clause is the clause that swallowed everything. Crosskey had an answer. Crosskey said, if you look at every one of the enumerated powers, which is always kind of a weird list, you're like, what is it about counterfeiting and piracy that got them going, right? Turns out everything on that list was something that had traditionally been seen as a prerogative of the king in England. And so Crosskey argued the reason for that list was not a federalism provision, because Congress is a government of limited to enumerated powers. The reason for that list was a separation of powers provision, to make clear that our president, unlike the English king, wasn't the one who had the power to coin money, the power to raise armies, the power to punish counterfeiting, and so on. So the enumerated powers doesn't even serve the purpose we think it does. It's actually there to move power away from what would be kind of the inherent executive power of a king to Congress to make sure our president was not a king. Here too, a lot of modern scholars now think Crosskey was right. Professor Michael McConnell at Stanford, formerly Judge McConnell of the 10th Circuit, has an important new book on presidential power, The President Who Would Not Be King. And he essentially reinvents the same argument as he goes through all the list of the powers. He says, wow, it's so strange. These all map onto the king's prerogatives. And then he concludes that the reason for that is exactly as Crosskey said. And he credits Crosskey for this. He says, it's, Crosskey was the first one to spot this. And he builds a theory of executive power out of this. Several other constitutional scholars have started to conclude the same thing. So again, not so crazy after all. Now, the other obvious objection to Crosskey's view of the Commerce Clause was that if you look at the records of the Constitutional Convention or the Federalist Papers, they say the opposite. They're full of people saying the government's a limited government of enumerated powers, that's not what the Commerce Clause means, etc. Which brings us to Crosskey's fourth idea. James Madison was a liar. So one of Crosskey's points was the Federalist Papers can't be taken wholly at face value. They were a political document designed to get the Constitution enacted because New York was the pivotal ratification state. People were worried that people were on the fence. And so Madison and Jay and Hamilton, poured out there and gave the doubters everything they could think of to convince them the Constitution wasn't so bad. Everybody knows that. That's obviously right. The more interesting question is, what about the records we have of the secret convention where they were drafting the Constitution? Right? The Constitution was drafted in Philadelphia in 1787 in secret, so they don't seem to have been performing for the crowd. And we now have a pretty good set of the day-to-day records of the drafts they considered and why, and the things they did and the moves they made. And there, too, there seems to be a lot of evidence against the Crosskey thesis of plenary national power. But almost all the records we have are James Madison's handwritten notes of the proceedings. He was the guy who figured out early on, right, that you should bring a legal pad and write stuff down. And if you do, you might control the narrative. It's a lesson you should keep. And so the published notes we have are a compilation by Professor Max Farrand in the early 20th century, largely drawn from a published set of notes by James Madison in the middle of the 19th century, setting forth what happened. And Crosskey said, I just think Madison was making it up. I think Madison, especially later in his life, because the notes only come out quite late in Madison's retirement. Later in Madison's life, as he'd become more of a Jeffersonian states' rights person and was trying to kind of like repivot and reclaim his legacy, he just like repositioned himself and the Constitution as if it was not the nationalist document that I, Professor Crosskey, am convinced it really was. I mean, this was also not well reviewed. The leading Madison biographer wrote, I don't know, between James Madison and William Crosskey, who are we going to believe? Funny story. A few years ago, a professor, Mary Sarah Bilder, wrote an award-winning book called Madison's Hand, where she goes to the National Archives and gets all of the actual parchment paper of James Madison's notes to the Federal Convention. And through careful analysis, discovers he did make a lot of edits. Late. And now people kind of knew that, but the standard view was, he was writing in shorthand, and then he later made some edits to, just make them more readable. But she goes through and pretty systematically shows that the edits were substantive. That there were lots of ways in which, at the time the Constitution was being drafted, people had not fully coalesced on questions of what the nature of the Constitution would be. And Madison, only decades later in his life, went back into the notes and altered the record of history to make the draft of the Federal Convention line up with what he thought constitutional history had become since then. So Crosskey, again, is kind of onto something. Okay, put aside national power. So that's one of Crosskey's major contributions, but there are more. Crosskey's other big and most controversial contribution, maybe even more controversial at the time, was his argument that the Privileges and Immunities Clause of the 14th Amendment incorporated the Bill of Rights against the states. This was regarded as crazy talk. This was one of the biggest constitutional debates in the middle of the 20th century. The Supreme Court had dozens of cases about whether to incorporate the Bill of Rights against the states. And in general, the debate pitted the fancy people against the non-fancy people. So the leading view of incorporation, Professor Crosskey, here in Flyover Country. By the way, while I made his law school record sound good, it is worth noting he took him 8 years to graduate college because he had to keep taking time off to sell aluminum siding to be able to put himself through. So he was kind of a non-traditional student. Pitted Professor Crosskey against Charles Fairman at Stanford, who was regarded as an incredibly important and sophisticated constitutional law teacher. He was Justice Rehnquist's constitutional law teacher back in the day. On the Supreme Court, even worse, the incorporation debate pitted Hugo Black, a generally regarded as a rube, a practicing lawyer in Alabama and a politician, about whom one of his colleagues once said, Hugo Black has only ever read 2 books, the US Constitution and the Bible. And Black thought that was a compliment. Against Felix Frankfurter, one of the most prominent Harvard law professors, then turned Supreme Court justice, who thought the idea that the Privileges and Immunities Clause secretly revolutionized American federalism and nobody noticed until the 1940s was just more crazy talk. So there are tons of cases about this in which, for the most part, the forces of Felix Frankfurter prevail at first. The court says, the Privileges and Immunities Clause was declared basically a dead letter in the slaughterhouse cases, and we're not bringing it back. And Justice Black's various arguments that he can comb through the debates and prove it was really supposed to incorporate the Bill of Rights are not convincing. Then Crosskey and Fairman get in on the debate. Interestingly, Crosskey seems to just come to this, again, out of his constitutional project. Fairman, according to some papers in the Fairman papers, seems to have been put up to it. Robert Jackson writes to him and says, you're a big deal constitutional law professor, and a lot of my colleagues really care what you think. And this Black guy is kind of trying to convince them that the Bill of Rights is incorporated. So it'd be great if a really smart law professor would look into this and hopefully tell my colleagues that he's wrong. And so Fairman was like, all right, I accept the assignment, and wrote an important law review article arguing that Black and Crosskey were wrong. The Privileges and Immunities Clause didn't really have a clear meaning, and whatever its meaning was, surely it wasn't supposed to incorporate the Bill of Rights against the states. That was, at the time, Crosskey's most prominent actual influence in the law was getting a bunch of dissents from a justice that a lot of people regarded as not the sharpest tool in the shed. Now, as you may know, the Bill of Rights has been incorporated against the states. While Frankfurter won the battles of the time, the court adopted something called partial incorporation, where it would decide on a case-by-case basis whether some right was sufficiently important to incorporate. Eventually, the court gave up and incorporated everything, except for maybe the Third Amendment and the Seventh Amendment trial by jury, which they've pretty much admitted is just largely because they haven't gotten to it yet, and they don't have a lot of cases about it. So the Bill of Rights is now incorporated against the states. Now, the courts incorporated it using the Due Process Clause, not the Privileges and Immunities Clause, because the slaughterhouse cases declared the Privileges and Immunities Clause a dead letter. But the court has actually now said in 2 majority opinions, yeah, it should be the Privileges and Immunities Clause. It's the Privileges and Immunities Clause that was supposed to incorporate the Bill of Rights against the states. It's true, we're using the Due Process Clause now because that's sort of how the path has worked. At some point, maybe we'll fix it and get it back to the right clause. So again, Crosskey's hour come round at last. All right, just a few other examples. These are not places where Crosskey has been as victorious, but worth mentioning. The Import-Export Clause of the Constitution, which I dare say most of you have probably never read, which forbids states from taxing imports and exports. Clause basically has very little importance because under modern doctrines of foreign affairs and foreign affairs preemption of the Dormant Commerce Clause, we wouldn't expect states to do a lot of their own tariff policy against China. But Crosskey said, actually, the Import-Export Clause of the Constitution is not about whether states can regulate goods from China. It's about whether states can tax goods shipped from one state to another. Import and export actually referred to interstate commerce. And this is the textual basis for what we now call the Dormant Commerce Clause, the rule that one state can't discriminate against the commerce from out of state. Justice Thomas is there. In a very important dissenting opinion, a case called Camp's Newfound, Justice Thomas and Justice Scalia say the Dormant Commerce Clause is not a thing. The Commerce Clause, after all, is a grant of power to Congress, not a removal of power from the states. But they say there are some other clauses that were maybe supposed to do the work. And they rely on Professor Crosskey to say, it looks like the Import-Export Clause was supposed to do a lot of the work until the Supreme Court misinterpreted it in the middle of the 19th century. I think Justice Thomas has relied on it just recently in one of the court's most recent Dormant Commerce Clause cases. Another example, the ex post facto clause. Congress cannot make ex post facto laws. Since the 1790s, the Supreme Court precedent has been, this is only about criminal laws. They can't pass a law that makes what you did yesterday a crime. But they do pass laws that change investment-backed expectations all the time, that even create liability, create taxation, sometimes for things that you've already done where you have reliance interests. Crosskey argued this was wrong, that the ex post facto clause was supposed to apply not just to criminal legislation, but to civil legislation. It was a general prohibition on retroactivity for both the states and the federal government. Justice Thomas has recently announced that he thinks we ought to reconsider Calder versus Bull, the oldest precedent on the list of precedents Justice Thomas thinks we should reconsider. I mean, it's one of the oldest precedents of the Supreme Court period, so it's going to be hard to find one before that. Once again. Last example, Justice Brandeis's famous handiwork in Erie Railroad versus Tompkins. A substantial portion of Crosskey's work is devoted to explaining why Erie was wrong to say there's no such thing as general federal common law, and that it represented a total mistake about how to understand the nature of the common law and unwritten law, the role of state courts in making law versus finding it, and the nature of what was even happening in the 19th century in terms of unwritten law. No justice has yet said it's time to overrule Erie Railroad versus Tompkins, although Professor Jack Goldsmith predicts we'll get one soon. But again, some of the Harvard people are coming around. Stephen Sachs, recently installed as the Antonin Scalia Professor of Law at Harvard Law School, gave a chair lecture upon receiving a seat called After Erie, describing the rumblings that have been discerned by legal seismologists about the possibility that maybe Erie Railroad is wrong about something, and devoting his essay to what life will look like after Erie, to how the law will operate on the happy and glorious day when Erie has been overturned. So maybe Crosskey's greatest victory is yet to come. Now, to be sure, a lot of Crosskey's arguments for these points had problems. I will say the idea that commerce among the several states actually means all stuff done anywhere in the United States by anybody. It's not clear how well it holds up. As we've done more review, even of the materials Crosskey looks at, other debates that Crosskey doesn't fully account for. His argument that Congress has a lot of power, again, has sort of come into vogue again, but I don't know. Does it really hold up? Crosskey's understanding of the 14th Amendment. He's clearly right that the Privileges and Immunities Clause was the central focus of the 14th Amendment, and that it was supposed to incorporate a lot of the protections of the Bill of Rights against the states. But a lot of the modern scholarship, my own included, so maybe I'm biased here, suggests that it wasn't a simple matter of taking the Bill of Rights and incorporating it against the states. Instead, it was a question of what are the true privileges and immunities, the fundamental rights of American citizens, many of which, not coincidentally, were things like freedom of speech and the right to keep and bear arms and the right to security in your house, but not because the list of random things in the Bill of Rights is directly incorporated, but for a more complicated reason. Similarly, and this is the one I find the most ironic, while Crosskey was right that James Madison was a liar and a forger, his specific claims of what he thought Madison had changed do not seem to have held up to the archival evidence. So he was right about Madison's character, but wrong about the documents, which is funny because he started with the documents, became convinced that he must know what the Constitution meant, and James Madison, who was telling him otherwise, couldn't be trusted. So he was on to something. James Madison couldn't be trusted, but maybe the documents weren't always what Crosskey thought they were. So a lot of the arguments, don't necessarily hold up. In that sense, maybe the fact that Crosskey has met the fate he did is a little bit of his own fault. People also describe, in general, Crosskey's style and his method of academic production as not always working to his greatest advantage. Some of this is admirable. They say he refused to play politics. He refused to go to foundations chasing money that would let him hire fellows and send them into the world to promulgate his ideas. But he also seems to have had a strain that was pretty much convinced he knew everything there was about the meaning of the Constitution, and anybody who had any counter-arguments must just be an idiot or a liar, and sometimes both. So there's an issue there. All right, last question. So what do we learn from this? Right? What are the implications of Crosskey, one of the original originalists? What are the implications of his work? What should we think about that today? One possible lesson, the lesson drawn by the great Professor Philip Baude, who I quoted earlier, is that Crosskey's failure is basically a cautionary tale for all originalists, or what Baude calls the historical modality. Right? The fact that this smart guy producing thousands of pages on the original meaning of the Constitution, went so wrong in so many places, and was such a dud in terms of actually accomplishing his ideas at the time, it is a sign that becoming a true originalist is a little bit like becoming a madman, right? There's some fundamental truths there, but it just like leads you off into a crazy world, and you won't be able to really like interact with the law or think about the real meaning of the Constitution if you take it too seriously. That's Baude's lesson. Or, here's Hart again. If the composite conclusions of the commentators are sound, Crosskey's work as a whole may be dismissed as a passing curiosity, of value only for its provocation to rethinking, and for those bits of fresh evidence it brings forward that may survive a careful checking. Or maybe its significance lies in its reflection upon the quality of American scholarship as a whole, which has permitted so many scholars to be shaken loose from the intellectual moorings of a lifetime by a farrago of fancy rendered plausible only by a confident tone, nice printing, and an abundance of notes and appendices referring to obscure documents and esoteric word meanings. In other words, Hart thought the main lesson of Crosskey was how depressing it was that so many people thought he was good and were able to be led astray by this like confident, nicely printed originalist. I think Hart's on to something here, that part of Crosskey's significance actually is what it tells us about constitutional law scholarship as a whole and methodology in a whole, but in a different sense. So one important thing about thinking about Crosskey's influence is that the standard narrative about originalism as a method of interpreting the Constitution seems to be missing something important, right? The standard narrative is something like originalism was basically invented as a real methodology, like something you did as a program, not just like as one method among many, by Robert Bork and Anton Scalia and Ed Meese in the late 1970s and early 1980s. This is just wrong, right? Crosskey was there first, decades earlier. Not a debater's point. Crosskey was Robert Bork's constitutional law teacher. And in 1949, a group of law students tried to create a political party to nominate Crosskey to be president of the United States. The primary qualification for membership in the party, they stated, was acceptance of Mr. Crosskey's theory of constitutional interpretation. The name of this party, the Constitutional Federalists. So is Crosskey the real inventor of the Federalist Society? All right. So too, the narrative that's part of the standard Bork-Scalia-Meese narrative is that originalism was fundamentally invented as a conservative project, right? It was invented as a way to repudiate the Warren Court, or the slightly more much more sophisticated of analysis of Professor Kalven Terbeek. It was invented as a way to sort of triangulate the needs of social conservatives and economic conservatives and racial conservatives, each of whom had different beefs at the Warren Court, but couldn't quite figure out how to put the coalition together until somebody gave them originalism as a way to wrap it all up together. Crosskey was a New Deal liberal, right, who came to originalism by way of his strong belief that the Securities Exchange Act was constitutional. He prominently defended Roosevelt's court packing plan, believed strongly in the constitutionality of a lot of federal regulation. Nothing about the project, I mean, I guess if there were politics involved, they were politics of a very different side. So it's not true that originalism was invented by Robert Bork or invented for conservative reasons, right? Perhaps Bork saw in Crosskey's methodology, being used in a very different set of political arguments, some kernel of truth that he thought led in a new direction. And that's a very different story about how originalism works and why people use it to do different things. More fundamentally, right, is the Crosskey project, right? Crosskey was convinced that constitutional law had real answers that were often obscured by politics. The present misconceptions, he said, are products of the many attempts that have been made throughout our history to distort the Constitution to serve some political end. And he was convinced that a lot of study of the actual materials, the historical materials in the constitutional text, could lead you to figure out what the Constitution actually said. And he pointed out, since what the actual Constitution is the thing that members of Congress and Supreme Court justices and the president take an oath of support, it would probably be pretty important to figure out what it actually said, rather than just to allow all the misinterpretations to work today. And I tend to see Crosskey's successes and his mistakes in that light, right? People will always get more or less excited about originalist arguments, or originalism generally. In practice, people will get more or less excited about it based on whether it helps them get what they want in a particular case, right? Does originalism let us overturn Roe versus Wade? Great, some people want it. Or does it let us say that Donald Trump can't be elected president? Great, other people want it. Does it let us preserve birthright citizenship against an executive order? Right, another set of people want it, and so on. But the job of serious constitutional lawyers, and especially serious constitutional scholars, is to try to brush away the cobwebs of politics and figure out what does the Constitution actually require, in the hope that at some point that's something people will want to know. So as I see it, Crosskey's major steps forward, and there are many, right, help get us closer to a place where originalism is working itself pure, where we'll eventually, hopefully, figure out what the Constitution actually requires in this range of topics. Crosskey's mistakes give us reason to course correct, right? We can say, okay, Crosskey was on to something very good here. He seems to have missed this important point. Now, where does that leave us? How much was he right about? How much was he wrong about? But it's one of the important steps in trying to figure out what does the Constitution actually require and what are the things we've been missing. And maybe most importantly, Crosskey's commitment to that as a project, right? His willingness to spend decades trying to figure out the answer to that, and to take his chances that the answers might not be what people wanted to hear now, but at some point we'd be glad to hear them later, right? Remind us what constitutional law can be, something other than politics by another name. Thank you. Questions? Shia.
Thank you, Professor Baude. You mentioned that Crosskey believed that a lot of the enumerated powers in Article 1, Section 8 are actually separation of powers provisions, trying to move the royal prerogative to Congress. Would that militate in favor of some sort of non-delegation doctrine by implication?
So the question is, does Crosskey lead us to some sort of non-delegation doctrine? Perhaps, right? So perhaps the idea would be, by moving these royal prerogatives from the executive to Congress, they're also suggesting it's something Congress has special responsibility to carry out. It's going to replay some of the standard debates about non-delegation. You might say part of how Congress carries out its power to coin money is to say to the coiner of the mint, coin some money. And to quote an early non-delegation debate, it's not as if members of Congress have to go into the mint and turn coiner themselves, right? Or when they have the power to set up the post offices and the post roads. There's going to be a lot of decisions about the post office that they leave for the president to make. So maybe it's more fundamental how they interact with sort of debates about the unitary executive and the nature of the executive power. The point is that all those powers in our Constitution fundamentally come from Congress. So whatever the laws are Congress has about spending money, running the post office, et cetera, are choices Congress makes, not things where the president can say, I'm the one who really holds the power here and Congress is regulating my true powers. Yeah.
Does Crosskey's interpretation of states also do anything with the 10th Amendment, or does he just kind of glide past that?
No, so the 10th Amendment, this is one of the points in which Crosskey's actually occasionally been cited by a Supreme Court justice. So Crosskey unearths and emphasizes the fact that the 10th Amendment was amended. That an early draft of the 10th Amendment was going to say Congress can only exercise the powers expressly given to Congress, and they took expressly out. He argues that was very important because the Constitution contained a lot of not quite expressed powers. And so he sees the amendment as the 10th Amendment as reflecting his view. He also actually had a whole shtick about the Bill of Rights. I left out of my 8 points. That the Bill of Rights was not something they really cared about. And it was a political document. In fact, there's a quote there's a quote he uses that's now been picked up by a lot of historians. The Bill of Rights was like a tub to the whale, which is what you do when you're trying to lure a whale on a particular path so you can kill him. The idea was the Bill of Rights was there because there were people who were complaining about the Constitution having too many powers, and so they gave them the Bill of Rights, but not with the plan that was going to do anything. Yeah.
So I have a question about method. So in terms of how close of an analogy you have to find in a contemporary moment for it to have also been somewhat present at the founding, does he sort of elaborate on how precise it has to be in terms of one-to-one correspondence before you can say if there's an historical analog for this particular?
Yeah, so this is kind of picking up on now, one of the court's moves is when the court does various forms of historical analysis. It says, for this to be constitutional, we need to find some evidence that it was done in the past, and is there a historical analog? So Crosskey sort of rejects the analogs approach entirely. Crosskey's more of a textualist. So he would say, The real question is just, what does the Constitution say? And so there could be things in the Constitution where it was understood to give Congress broad power. They may not have exercised it, but that doesn't mean they lost it as long as it was there in the Constitution. So the way he sees it, it's true at the founding, after the Constitution is ratified, that there's a lot of stuff that Congress doesn't do that they could have done. And he would say, that's because politics were keeping them from doing it. A lot of people didn't want Congress to have a lot of broad power, and that's their prerogative. But the question was always, well, what was on the table sort of constitutionally? And so his method, and he explicitly describes it this way, is to try to sort of reconstruct a founding era dictionary by going through all the sources of people talking about all stuff, and then reconstruct what do the words mean, and then use that really as the guide, rather than to get stuck in particular examples and particular analogs. Yeah.
Just kind of going off the method question, what do you think Crosskey would say, the idea that there are things that are clearly left undefined? So I'm thinking of the Madison and Van Buren letters in the 1820s, talking about how we didn't really consider internal improvements, how the commerce power applies to that. And so does he assume that everything is kind of defined in the convention, or?
Yeah. So I think the way he would describe it, and again, remember, James Madison was a liar and a fraud, according to Crosskey. He delivered a famous lecture on John Marshall that's not kind either. Marshall was on the right side. He was just hamstrung by the Jeffersonians and doing the best he could to get through it. I think the Crosskey idea would be, it's not so much that things were undefined, it's that they were very, very broad. So they might not have thought about all the things Congress could do, with all the power they were giving to Congress, but it was clear that they were giving it to Congress. Another part of the book is about the limited power of the Supreme Court of Judicial Review. So he thought when there were questions about how broad the power was, the Supreme Court was not supposed to be the one to strike down acts of Congress on doubtful questions. Acts of the states, sure, but acts of Congress, no. So the ultimate theme for what to do with any kind of ambiguity was, it's up to Congress. And indeed, the books are actually dedicated to the Congress of the United States, in the hope that it may be led to claim and exercise for the common good of the country the powers justly belonging to it under the Constitution. That's the vibe. Yeah.
So it seems like he sort of attacks the Federalist Papers and a lot of other kind of public expositions of the Constitution in favor of this kind of esoteric, private, he edited his notes before he published them, that kind of thing. Doesn't that sort of attack ordinary public meaning in favor of kind of an esoteric legislative intent?
Okay, great. So, Crosskey's definitely esoteric in multiple senses of the word. But actually, his methodology is a little more interesting, right? So he rejects the use of Madison's notes, which are in a sense private, although private and then manipulated his Madison's complicated. He rejects the Federalist Papers, which are public but insufficiently public in a way, because they're just part of a political campaign in one state with the ratification. A lot of the body of evidence he relies on is word usage outside of the constitutional debates at all. So part of what he did, and you can go through the Crosskey papers from the rare book in the library. Part of what he did is just go through stuff, people talking. It was sort of a non-computerized version of corpus linguistics almost. Just every document, people talking about different kinds of the country and people, what they were doing in all sorts of contexts. And he tried to accumulate them systematically and put them together and draw out of that the kind of ordinary meanings of the words in a non-legal context. And then argue that's what the Constitution meant in its legal context. Now, yes, that led him to not even credit very much public debates with the ratification of the Constitution. That's politics. By then you can't really trust anybody what they're saying, right? We really just got to figure out read their books, read their newspaper articles, figure out how they talked, and use that to reconstruct a dictionary that lets us figure out the language the Constitution was written in. Yeah.
One of these interesting themes in the talk is this kind of interplay between conviction and humility. And so I just wanted to ask you, as a general note in constitutional law, how do you think we balance these two? Because you can't have no conviction, obviously, or else we wouldn't have gotten the book. But I think a huge theme of your talk is that you can't be too convicted in what you believe.
Constitutional law professors are not known for their humility. I don't know that I have the answer to that. I will say there's an interesting point made once in a lecture by Frank Easterbrook that there might also be an important division of labor on that question between scholars and judges. So what Easterbrook argues is, free thought is likely to lead to mistakes, right? Most mutations in genes are harmful. A few of them are really beneficial for the species. Most weird ideas are wrong. But the way scholarship works is that most ideas are bad, most of them are discarded and forgotten, and the best ones people build on a little bit the next time. And so I think there's something to that suggests that, like, for a scholar, part of what you're doing is to add to what's known, and it's important for you to try to get out there stuff you think is missing. And then you gotta let people figure out whether it's actually useful and let it play out. For a judge who actually has to decide cases where, real people's lives are on the line, you maybe shouldn't have the same attitude of, well, I'll just try stuff and it'll get overruled or discarded later if it doesn't work, right? As a judge, you might have more responsibility to be more humble, to try more carefully. So maybe Crosskey was doing it the right way because he was acting as a constitutional law scholar, and we could ignore him for decades when we weren't ready for him, and his books are still there for us to dust off now, maybe.
Was there any tension between Crosskey's view of the Bill of Rights when ratified, which seems that they were relatively weak, and then his view of the 14th Amendment incorporation? Did the 14th Amendment reinvigorate the Bill of Rights in his mind? Or?
Yeah, that's a great question. I think there are some tensions. So Crosskey's view about the incorporation of the Bill of Rights partly came from a close reading of the debates at the time the 14th Amendment was enacted, and from reading those debates against Dred Scott, a decision that didn't exist at the founding, wasn't necessarily anticipated at the founding. And so I think part of the idea would be, yes, when the Bill of Rights was created, the Constitution is generally a very nationalist document that has broad national powers. And so the Bill of Rights was not supposed to do a ton of work. Then, when the 14th Amendment is added, that's also a very nationalist document, but it was in some ways recovering some of the nationalist things about the Constitution that had maybe been neglected, and building off of legal context that generated since then. So I think he'd resolve the tension in part by being a 1868 originalist for the 14th Amendment and a 1789 originalist for the original Constitution. But there are a lot of things. There are a lot of things in Crosskey's thought that don't totally add up, and I won't try to convince you that they do.
So you make an argument that Bork and Nice and Justice Scalia probably were just creating originalism out of thin air for their political beliefs. And you say Professor Bork, was taught originally by Crosskey. So I'm curious whether Crosskey himself had any originalist influences on him, maybe any proto-originalists that he cited, because we know during the Reagan era, they always said that originalism was the original way to do constitutional interpretation. So who did he rely on, if anyone?
That's a great question. So Crosskey wrote surprisingly little, or sounded little, about his method of constitutional interpretation. Like, he says at the beginning, this is what he's doing, and he says why, but he doesn't spend a lot of time talking about why this is the right way to interpret the Constitution. So I don't yet know. There are probably answers to this, and could figure out who he had at Yale Law School. Was there anybody there? He seems to have thought, though, that the fall from grace happened pretty fast, right? That even in the first few years of the Constitution, already there was a lot of politics. People were starting to lose their way on interpreting the Constitution. So I'm not sure who he was relying on there. One of the only things he really grounds it on in his introduction to his book is the constitutional oath, and says that sort of requires originalism. But I don't know if he got that from somewhere or where and how.
So related to your point about originalism working itself pure, do you think it's a good thing, and would Professor Crosskey perhaps think it's a good thing that now we have conservative and progressive originalists fighting each other over what the actual meaning of the Constitution is? Or do we need apolitical, saintly originalists to just be devoted to the truth and nothing else?
Yeah, that's a great question. I don't know. I think I'll just guess. My guess is, Crosskey's first choice would be the second, would be, he'd say at least, in law school, right? This is supposed to be a place of serious scholarship and intellectual rigor, and constitutional law professors ought to be just trying to figure out what the Constitution means. That should be their main thing. Now, if you told him, I got good news and bad news, the good news is a lot of people are going to care about originalism, but the bad news is none of them are going to be apolitical originalists with intellectual integrity. They're all going to be political. It's just going to be different directions. I don't know. Maybe he'd say, well, that's better than nothing, right? And we do have a tradition in the United States of the adversary process as a way of helping us get the truth. And so we'd at least be returning to some ways like the 19th century when there were people on both sides, lots of questions, both making arguments from the original meaning of the Constitution. You hope get something out of that. But my impression is that he'd be hoping for something even better. Maybe we'll get it one day. Yeah.
So this seems to be a bit of a multi-generational conversation that starts in 1789 and then it sort of just alters in the 50 years later, and then Crosskey has had something in the 1950s, and now we're interpreting what Crosskey has said about the things that were written beforehand. So are we sure that the word state means today what Crosskey thought it meant in the 1950s? And isn't this whole just a futile attempt that's becoming more futile as long as time goes by?
Right, are we sure? So the answer to the first question is no, we're definitely not sure Crosskey was right about the meanings of a lot of these things. In fact, I'm pretty sure Crosskey was wrong about at least some of them. Maybe not all of them, but maybe some of them. Does that mean the whole enterprise is futile? And does that mean it gets harder as we go on? Right, this is actually one of the hard questions about the arc of constitutional law scholarship. Maybe, right? So obviously one view would just be the further you get from the founding, the more of a foreign language it is, and the more hopeless it is to try to recover it. This is one of the arguments for instead a form of common law constitutionalism or living constitutionalism. Right? You'd say when you're several hundred miles from home, like you don't worry too much about whether you took the left or the right getting out of your driveway. Like it's just moot now. On the other hand, actually, some of the ways where we now know Crosskey is wrong might cut the other way. Like so Crosskey was sort of, as I suggested, trying to invent like an idea that now we can use, we use computers to do, and soon we'll be using large language models to do, of just trying to get all the documents we have and all the ways people spoke and trying to put it all together to figure out what the words meant. He was doing this just like in the library and in the archives in a bunch of different places by hand, right? Taking notes on note cards every time he saw a word. He's like, oh, I saw that word before. We can now do that a lot better. So in some ways, our technology to understand the original of the Constitution may have improved. And that there are versions of that throughout history, right? So the 19th century, nobody knew what happened at the Federal Constitutional Convention because James Madison's notes hadn't been made widely available. Big revolution when like suddenly you can buy them at a bookstore and lots of people in constitutional law classes can at least kind of understand what happened. So maybe sometimes there's just our knowledge, actually, our ability to analyze the past increases over time. And then the other question is this politics question, right? So it might be that accumulating more distance from the founding can sometimes help us see past our political blinders a little bit better. Like it's when you're in the middle of a big constitutional question, it's so hard to see past. Like these are the implications for this today. But seeing somebody who was in the middle of one big constitutional convention, the things they thought about, and then the next person the things they thought about, and the next person the things they thought about, and then letting us kind of try to connect the dots and see the through line might sometimes actually give us more perspective over time. I mean, that's a big bet on the future of constitutional law, whether it's like going up or down. I'm sort of invested in it, I guess, although I could always just switch to conflict of laws, but I'm hoping it's going up. Yeah.
So I'm curious if Crosskey had a sort of normative defense of originalism. So one thing you could argue, and this is going off the intergenerational point, is that originalism might not comport with democratic norms. It's what you're doing, especially if you conceded that it seems like a lot of the interpretations, at least that the founders had, were political interpretations. So essentially you're taking a set of interpretations that no one in the present consented to when there's like a contemporary sort of understanding of what these words mean or should mean, and imposing it through the law. So is there sort of like a defense of why we should prefer one interpretation over another if there's a sort of popular consensus about what the word should mean?
Yeah. So this objection is often part of what's often called like the dead hand problem, right? It's like, why should the choices made by somebody enacting a text a very long time ago exert this dead hand over today's law? It's not something Crosskey wrote about much, so I don't know. There are a set of arguments that have been marshaled in modern constitutional scholarship. Like, it was a more democratic time in some ways. It's a time people actually got together and tried to figure out the amount of energy sort of relative to the day that was poured into the Constitution created a special constitutional moment, or the idea that people over time kind of have decided to become part of this intergenerational conversation, and so that gives us each a stake in it, and so on. Crosskey didn't write about any of those things. In some ways, it was easy for him because his takeaway was that the Constitution actually gives much more power to Congress than people realize, which is the national representative branch, and much less power to the Supreme Court to stand in the way of Congress's stuff in the name of all this federalism mumbo jumbo. So to him, there might not have been as much of a dead hand problem in saying he's trying to actually free up the power of Congress to legislate in the way that it was originally given by the framers. So maybe it was just, a happy accident that he didn't have to worry about that as much. Yeah.
Yeah, going off the conversation about Article 1, Section 8, primarily portioning powers, and maybe not being limited to just like what those powers were. I'm curious about what he thought of the nature and source of Article 2, like the executive's powers. If Article 1 is primarily basically funnels powers away from what you might think the executive power might be. Yeah. And he dedicates the book to Congress, so I'm guessing Volume 2 might not be dedicated to the president. Maybe it is, I don't know. But yeah, like what would he say, or what did he say about the nature and source of executive power at that time?
That's great. So he did not write as much about executive power as we do now. I think that's his main conclusion was the executive is not a king and is much more subordinate to Congress than people would necessarily think. If he talked about the kind of what we now think of as like some of the questions of like, is there inherent unenumerated executive power? I'm not sure where he said that or what he said. So to him, I think Congress was first and the executive was not. It was sort of an afterthought. But also a lot of the constitutional questions we have now about the president's power over the administrative state and were not live questions at the time. He became a law professor before the Supreme Court had invented administrative agencies, Humphrey's executor. So to him, that might not have been the top of the mind. Maybe one more question? Go ahead.
Thank you, Professor. Following Adorjo's question about his influences, do you think him being a New Dealer influenced his very capacious conception of congressional power?
Did Crosskey's experience as a New Dealer influence his capacious conception of congressional power? Well, he would say the whole point is to put politics aside. Now, right, is it possible that wasn't what was happening? Is it possible that his fervent belief that the New Deal was totally good and totally constitutional influenced the way he approached the whole thing? It's certainly possible. It's certainly possible. Was also just a general split among people who were New Dealers at the time, though. There were a lot of New Dealers who thought the Constitution is made for the horse and buggy era. It's not well suited for today's problems. Right? Woodrow Wilson had written a whole dissertation about how the Constitution was kind of this fundamentally ancient document that couldn't work for the modern state. And so there were definitely people in Roosevelt's orbit who thought this is just further proof the Constitution's kind of broken. We gotta get through it somehow, stop following it, amend it, whatever. So Crosskey was taking a non-obvious position, although some other New Dealers took. It was like, no, the Constitution is fine. It's the Supreme Court's mumbo jumbo over the past 30 years that's gotten in the way that's the problem. Was that motivated reasoning or was that really his study of the materials? That I cannot tell you. Thank you all.